Okay, hello and welcome to this video lecture on behalf of Project Sathi. I am Dr. Animesh and I am here to help you with criminal law. So, this is the fourth lecture of our first module, that is elements of crime. In the last class, we discussed something about punishment. We discussed crime and punishment, and before that, we have discussed basic ideas related to criminal law and everything. And today, we are going to start with our primary discussion on criminal law, how a crime is constituted, what are the elements, what are the components of crime, how you can see what are the elements, what are the characteristics of a crime, when you can see a crime has been committed, and how a crime can be differentiated from an innocent act. So those elements that we are going to learn. Okay. So moving on, first of all, there are four elements, primarily there are four elements to a crime. The first one is involvement of a human being. You'll say, obviously, only human beings are subjected to criminal law. Although in some cases in modern criminal law, the responsibility is sometimes also fixed for the corporates or non-human entities. But even if the company is punished for criminal law, it is the person who is running the company, who is in charge or in the management of the company, is held primarily responsible for his act, for the act of the company. Obviously, if you are the managing director, if Sahara defaulted in the loan, it was Subrat Roy Sahara who was held accountable, or some kind of restriction was put on him. Similarly, if the Kingfisher has done something wrong, Vijay Mallya is held accountable. That is how it generally works. They do not take that is not a personal loan that Vijay Mallya has to. It was a business loan, but he was in charge of the business. That's why he is held liable. So even in those cases where company is held liable, it is the person who is running the company is held liable, who is obviously a human being. So human being is someone who is considered the person of inherence. Means it is the criminal law is only in respect of human being. शेर किसी को खा जाए, कुत्ता काट ले, बिल्कुल उस कुत्ते पर कोई criminal law नहीं लगता, obviously. Suppose I have what is a very ferocious dog, bulldog or something, na bulldog. If my bulldog harms someone, it is I who will be held liable, not my bulldog, obviously, because the criminal law has only application in respect of human beings. It does not have any implication towards divine entity. Like you cannot hold God accountable for anything that wrong has happened. Suppose lightning strikes you, मुझ पर बिजली गिर जाए, तो मैं जाकर इंद्र के खिलाफ एफआईआर, भगवान इंद्र के खिलाफ एफआईआर लिखवा दूं कि भाई मेरे पर बिजली गिर गई, इंद्र की गलती है. ऐसा नहीं है. That's not something that is plausible. Only human beings are subjected to criminal law. Another idea to this is that criminal law, the victim is ultimately also a human. There are some crimes which are directly there is an individual victim. There are some crimes of which society at large is a victim, like crime against government, state. If you commit treason, if you try to topple the government by violent means, everybody is a victim. Sometimes you do corruption, so everybody is a victim. You take drugs, everybody is a victim. Ultimately, the ultimate victim will always be a human being. That is why human being is also subjected to the crime law is made for the protection of human beings only. Even suppose even if we are protecting environment, cutting a tree is a crime under certain forest conservation legislations. That is also ultimately for the benefit of human beings. We are not inherently benevolent. Obviously, in Indian culture, we have an inherent respect for the non-living entities, but not in the Western construct of law that we are following. उनके अंग्रेजों के और जो भारत की परंपरा के नहीं है, उनके नजदीक everything is for the use of human beings. They do not have an independent existence, something to be revered. But we are obviously nature worshippers. All the people who are followers of Bharatiya faiths or are actually have assimilated into Bharatiya culture, they become nature worshippers. They give a certain reverence to the nature. But the law that we follow generally tries to protect animals or tries to protect plant trees for its own sake. We are trying to save tigers not for the love of tigers, but rather we want to preserve the ecology that helps the human being. That is why human being is at both the ends of the criminal law. Human being is someone who is subjected to criminal law, and the ultimate victim of every crime, everything that can be considered a crime, is also a human being. Okay, that being said, let's move to the other elements. There are two elements: wrongful act and guilty mind. If you have very basic idea about criminal law or something, even if you don't have, I'll give you an idea. पहले तो क्रिमिनल लॉ को समझने के लिए समझिए कि भाई एक गलत काम किया और गलत नियत से किया, बोथ आर वेरी मच रिक्वायर्ड. सपोज आई हैव वेरी इविल इंटेंट बट आई डोंट डू एनीथिंग अबाउट इट. मेरा मन में बड़ा आई वांट टू मर्डर समवन. वी ऑल मस्ट हैव some kind of guilty intent at some point of time. We all have evil thoughts. Sometimes you want to commit violence, sometimes you want to do something that is illegal, but we don't do that. If you don't do that, criminal law will say nothing. Criminal law will say fine. Till whatever you think, that is up to you. If you don't do anything about it, that's fine. Sometimes you do something wrong, but you don't intend it. Like in the cases, like the idea is that if I have committed something by accident. Suppose I am walking and my feet lands on another person's feet. I'll say, sorry, it was accidental. There are a number of harms that occur because of human conduct. But if it is not intentional, generally the criminal liability doesn't lie. If what you have done is not intentional, but rather accidental, involuntary, in that case, liability is not there. So both of these things, actus reus and mens rea. There is a Latin maxim from which these two terms emerge. That Latin maxim is called actus non fecit reum nisi mensit rea. Yes, there is a maxim. Yes, this is the maxim. Point 2. Actus non fecit reum nisi mensit rea. Now, actus non fecit reum nisi mensit rea means an act in itself is not punishable unless coupled with guilty mind. Means if you do not have a guilty mind, if your actions are innocent primarily, in that case you will not be held liable for the act you have done, because obviously it is the mind which is in which the crime is thought. What is criminal and what is not criminal is generally differentiated on the basis of what the person intended, whether he actually wanted to commit that crime or something that happened. Okay. So that is something very important. So actus non fecit reum nisi mensit rea has general application in Indian law. There is some truth to that statement, but obviously there are exceptions that we will learn. But these two elements are very important. आपने कुछ किया और गलत नियत से किया. अगर आपकी गलत नियत है पर आपने कुछ किया नहीं, या आपने कुछ किया और आपकी नियत गलत नहीं थी, तो obviously that will not considered a crime. So both of these things are required generally. There are certain exceptional cases that we will discuss, lekin in both of these cases are required. Then the last is concurrence. Concurrence is obviously that this wrongful act and guilty intent should be simultaneous. Simultaneous मतलब जब आप गलत काम कर रहे हो उसी समय आपकी नियत गलत होनी चाहिए. Obviously, if your intent is wrong when you are doing the act, then you are held liable. But if suppose you had guilty intent but you didn't do anything wrong, or you did anything wrong but you had no guilty intent, in that case, your liability will not be there. Suppose I want to kill A, but I was not doing anything about it. I never wanted to kill. I didn't do anything about it. I thought I'll be caught and I should not kill him. I wanted to kill him. I wanted him dead. But suppose I didn't do anything about it. One random day I was driving my car and brake fail ho gaya uska, and then the brake stopped working, and I simply ram into A, who is walking down the road. I didn't see him, and obviously the brakes were not working, so मैंने उसको टक्कर मारते A का देहांत हो गया. अब A was my enemy. Obviously I wanted to kill him, but when I actually killed him, it was something that was beyond my control. Brakes were not working. I didn't see that the person was A. मैं सीधा गाड़ी जाकर के भिड़ गई. क्या कर सकते हैं? कुछ नहीं कर सकते. So obviously here I had guilty intent as well as I have done something wrongful act. I killed A. But when I killed A, I didn't have the guilty mind. My intention was not wrong when I actually committed a wrongful act. So in that case, I will not be held liable. So that is something we call concurrence. Concurrence, what is we call theory of concurrence. Okay, moving on. Now we'll go into the detailing. Obviously, we'll detail what we have discussed. So in order to say that a particular act is wrongful, we'll have to understand what constitutes an act and what does not constitutes an act. See, देखिए, to say that a person has acted, it means he should have done something or might not have done something. Act or omission, both are considered act. Omission means not doing something. या तो आपने कुछ किया हो या तो कुछ नहीं किया हो. Now you can ask me कि सर कुछ नहीं करना कैसे क्राइम है या रॉन्गफुल है. तो कुछ नहीं करना तब रॉन्गफुल होता है जब आपकी ड्यूटी हो करना. If there was a particular duty, I had a legal duty to do something and I didn't do that, it means that I have committed an illegal omission. And if I have committed an illegal omission, I might be subjected to criminal law. I might be subjected to punishment. Like the very famous example, if I am a lifeguard at a swimming pool and somebody is drowning, somebody is saying, help, help, help. And I am just waving that person, no, fine, you drown, I don't care. Now the question is that I have killed that person. Like, yes, I have caused the death of that person because it was my duty to intervene. He was drowning on his own, but it was my duty to save him. So if there is a duty and you don't do that, that becomes illegal omission. So that illegal omission, and omission is only wrongful when it is omission despite having a legal duty. Right? Suppose you must have seen Spider-Man. Spider-Man में बिल्कुल Spider-Man beginning when the Peter Parker goes fights in a ring and he earns money, and then he goes and asks for money to the organizer. Organizer is not giving him money. So a thief comes to rob that organizer and he steals the money and he is running away. That organizer says to the Spider-Man, you catch him, you can stop him. Spider-Man said, no, it's not my money. Go to hell. So whether he has done anything wrong? Morally, yes, but legally, no, because it was not his duty to stop that thief. Suppose a thief is running in front of me, whether I am under a duty to stop him? No. But if I'm a police personnel, I am. Yes. If I'm criminal, I should stop him because I'm a police personnel. It is my duty to do that. If a crime is happening in front of you, you can stay silent. There's no problem. But if you're a police officer and you do that, then you have done something wrong. So illegal omission is only illegal, or it becomes a wrongful omission when there is a duty. If there is a duty, then I will be considered liable. That you might have seen. That's why we discussed this in our morality discussion. That if a person is drowning and I can save that person and I don't do that, then it is not a crime. Why? Because it was my moral obligation. But if I am a lifeguard, then I have a legal obligation. And if I don't save that person, then it becomes illegal. It becomes criminal. But if I don't do anything that was not my duty, it's fine. That is not an illegal act. Second, an act means something positive. Not doing something is omission, which is wrongful only if there was a duty to do that. But if there is no duty to do that, omissions are generally not considered criminal. If there was no duty to do that act. Similarly, an act can become wrongful. An act must be there. An act or series of acts. Now, this is very interesting. See, sometimes every act is made up of smaller acts, a series of acts. जैसे कि somebody says कि A ने जो है B का मर्डर कर दिया. मर्डर करने के लिए there must be 10-15 separate acts that must have been done. That must have been done, like उसने पकड़ा होगा and एक बार stab किया, 2 बार stab किया, hold down किया. There are n number of different actions which are different acts that have been done. And whether those series of acts might be innocent on its individual level, but together they are a criminal act. They are a wrongful act. I'll give you a simple example. I'll give you a better example. Suppose 5 people, they agree to kill someone. That okay, we'll poison him. In order to poison him, one buys, one makes shira halwa, something type. Another procures poison. One person mixes poison. Another person calls him there. One person serves him that halwa. All of them have done single act of poisoning that person and killing him. But all did different acts. One person cooked the halwa. One person bought poison from the market. One person actually mixed the poison in the halwa. And then one person called that victim to the place where the halwa was supposed to serve. And then one person served him the halwa. Now the question is whether they all will be held liable, whether they all have killed or not. Suppose the person who made the halwa says, I am not liable, although he was in on it. But whether his action can be considered to be wrongful or not? Answer is absolutely yes. It was a series of acts that ultimately led to the death of that person. So a single act can also mean a series of acts. Sometimes an individual act is not wrongful, but multiple acts, like you punch a person one time. It's a small thing, but you punch a person 100 times, that person will die. And if that person is dead, you will not punish the person for punching that I have only punched. So you punched once, but you punched 100 times, the person is dead. So you killed that person while doing several smaller acts like punching again and again. So your liability will be for the death, not for individual acts of punching. That is something that is very interesting in criminal law. Second is voluntary. Act has to be voluntary. Then it is can be considered as act only. When I say voluntary, it does not mean intentional. There is a difference between voluntary and intentional. Voluntary means what you did on your own. What you intended by it is a different thing. देखिए मैं क्या कर रहा हूं ये एक चीज है, और जो मैं कर रहा हूं उससे मैं रिजल्ट क्या चाहता हूं ये अलग चीज है. What I am doing is one thing that is voluntary, and what I intend to achieve by it is intention. So there are different things. So in order to be a wrongful act must be voluntary. It simply excludes two things. Number one is involuntary actions. Involuntary actions, which, for example, if somebody sleepwalks, something that is not in your control, like you breathe, you blink eyes. So those actions are involuntary. Involuntary means that you have absolutely got no control over it. Like somebody suffers from seizures. Somebody is because of a mental disease is unable to control his body. Or simply somebody sleepwalks. Suppose I start sleepwalking and I simply step on the chest of a person who is sleeping near me. Now is sleeping on the floor and I sleepwalk. I just put, because I can't see what is happening, so I plant my feet at that person's chest by mistake. That person's chest will crack. I'm a heavy person. That person is dead, let's say. Now the question is whether I have committed a wrongful act. Answer is no. Why no? Because I have committed no act. Because in order to constitute an act, it has to be voluntary. Voluntary means it must be result of my conscious action. It must be a conscious action. Similarly, it also excludes reflexes. Reflexes is something that is obviously not a conscious action. But in order to understand reflex, simply see that, okay, if you touch a hot tawa, you immediately drag your hand back. Immediately you touch it and you simply move back like that. That is because it is a reflex. You don't think it through. It's a reflex that is programmed in human being, that we have certain reflexive action. If you see a grenade unpinned in front of you, you will run away. If I take out the pin of a grenade and I give it to you, you catch. Suppose you catched it, and you will realize the grenade. You will immediately throw it somewhere. You will not think it. You have got no time to actually formulate a thought. You simply throw it wherever you can. And suppose that grenade landed on someone, somebody was killed. The question is whether you have committed a crime. The answer is no, because it was not your conscious act. It was a reflexive action. So you are not liable for the reflexive actions. No, you cannot. If there is something that is reflex, you're not to be held liable. There is a very interesting example that we used to take. Suppose a person is sitting right in front of you, and you have a knife, and you are showing the other person that knife. See, this is a very good knife, very sharp, very pointed. And somebody comes behind you and simply they are smoking a cigarette, and you have a knife, a hand like that, and they touch that burning end of that cigarette onto your hand. So what will happen? Immediately your hand will move forward. You will feel heat, and suppose you stab the other person who is in front of you. Now the question is whether you have stabbed that person, whether you have committed a wrongful act. The answer is no, because it was a reflexive action. So reflexes are not voluntary. That is why they are not wrongful. If anything you have done what it was mere reflex, in that case, liability is not there. Okay. Suppose you are asleep and somebody comes right to your face and says, and you raise, and you obviously our instinct is to think that somebody is an intruder, and you throw a punch and you break the jaw of that person. Whether that it is then there is any liability, answer is no, because that action was also what we call reflexive. Okay, so reflexes are not considered important. Third important element of a wrongful act is that it should have forbidden consequence. Now, this is very important. The crime is never in respect of act. It is always in respect of consequence. Whatever you do, we do not judge you by your actions. We judge it by the consequence that was the ultimate result of it. The consequence is the most important thing. जैसे कि गोली चलाई, किसी ने गोली चलाई, a person shot a bullet hit another person died. Now in this particular phrase, there are three terms. What can be considered as wrongful act? Now what makes this act wrongful? गोली चलाना अपने आप में wrongful होता तो फिर इतने सारे shooters हैं, पुलिस वाले हैं, आर्मी वाले हैं. Their act in itself is not wrongful. It is the consequence that has made it wrongful. It is always the consequence that makes the act wrongful. And that forbidden consequence is something very important. Whatever suppose you do is inherently wrong. But suppose the consequence which happened is actually not something that is forbidden by law. That is, it had no evil consequence. You did something that was inherently wrong, very callous. In that case, there was absolutely no forbidden consequence. Then nobody will be held liable. If it is like you went to Shimla and you took baraf, you took a handful of ice from the road. That doesn't belong to you. But obviously, it was in abundance, so nobody cares. It's not forbidden by law. Whatever you wanted to do, if the consequence is not forbidden. See, I'll give you an example. Suppose there is an act which is inherently innocent, but there are consequences which the law intends to forbid. Like sexual act. Two people doing sexual act is not at all wrongful. It's fine, very good. Provided it is consensual. If you remove the consent from that sexual act, that becomes wrongful. an act which is inherently not wrongful becomes wrongful just because the consequence of that act becomes wrongful because of the consequence, the forbidden nature of law that is attached to it. Law says without consent it is wrongful, with consent it is fine. With consent, but with a person who is not of a particular age, 18 years. A consensual sexual act between two people, but if done with a minor, it again becomes a wrongful act. So it is the forbidden consequence and not the act itself which is considered actus reus. If the law intends to forbid or prevent a particular thing from happening, then they will define it clearly. Now, this is the result that we don't want to see. We do not want a minor to have sexual relationship with someone. So that is why we are prohibiting even consensual sexual relationship with a minor is considered wrong. So an act itself, act of sexual relationship, if it was inherently wrong, then everybody who is having sexual relationship will be sent to jail. That is not the case. Those who are doing without consent will be sent to jail. Those who are doing it with a minor will go to jail, because that is something that is the consequence that law intends to forbid. So that is something very important. For in order to be called wrongful, the consequence must be forbidden by law. If it is an immoral act but the consequence of it is not forbidden, then well and good, very fine. You fire a bullet towards a empty space, you fire 100 bullets, no one will catch you. Obviously, if it was a licensed gun and you have target practice or whatever the case you are doing, in that case nobody will stop you. Nobody will say that you are doing a wrongful act. Let's say I am using a gulel on a tree to just pick apples, that is fine. But the moment you do it for the aim for head of for someone's body, it becomes wrongful. It is so the consequence is very important. And then we have fourth point is related to causation. Now causation is again a very interesting concept. What is interesting about causation is that we discussed that there is an act and then there is a forbidden consequence. These two things are there. What you did and what it resulted in is very important. In order to link these two things, there is something called causation. Causation का मतलब है जो forbidden consequence हुआ है वो आपकी वजह से हुआ हो. If it happened because of your act, then only it will be considered a wrongful act. Okay, your act must be the result. Your act must be the cause of that forbidden consequence. जो आपने किया हो उसका रिजल्ट होना चाहिए. समझ पा रहे हैं आप लोग मेरी बात? जैसे कि मैं आपको एग्जांपल देता हूँ बहुत सिंपल. मैंने किसी को शूट किया. I shot someone with a gun. That gun injured that person, that went right through the head of that person. The person died because of obviously trauma injury हुई, death. In that case, I will be held liable because death was the consequence that law was trying to forbid, and my action of shooting a bullet aiming towards the head of that person is my act. तो क्या वो जो consequence हुआ है वो मेरे act की वजह से हुआ है? If the answer is yes, my act is wrongful. If that answer is no, then my act is not wrongful. है ना? Suppose मैंने किसी को पानी दिया. I gave somebody water. Somebody drank that water and died immediately because of heart attack. Now somebody who is observing will say कि इसने पानी पिलाया और पानी पीने से उनकी डेथ हो गई. But if you go to a doctor will say no, drinking water had nothing to do with it. Or even if suppose that person somehow the water went into the windpipe of that person. Sometimes we choke on things. Suppose I served somebody rajma and that person choked on rajma. Or any hard candy, I gave somebody a candy and that person choked on candy and it went into the windpipe of that person died. Now the question that will come, ki whether my act has caused the death of that person, the answer is no. His death is not the direct and probable consequence of my act. Nobody dies because they have been served a candy. You drink a candy because obviously the candy was served, that candy he had, and that candy went into in the windpipe, and the person choked and died. So if a person chokes and dies, that is not because of what was served to him. If that thing is not inherently dangerous, if it was not inherently dangerous, if it was a candy, that can happen, obviously. So the causation is very important. मेरे एक्ट का डायरेक्ट कॉन्सिक्वेंस वो होना चाहिए जो कि क्रिमिनल कॉन्सिक्वेंस है. मेरे एक्ट का डायरेक्ट कॉन्सिक्वेंस नहीं है, but my act is a very remote factor in what happened. Like I gave the candy and the person choked on candy. Every time a person is given candy, they don't choke. मेरे एक्ट का नेचुरल कॉन्सिक्वेंस ये नहीं है कि कोई व्यक्ति मर जाएगा कैंडी खिलाने से किसी को, नहीं. If that person died, my action was not the direct cause of that particular consequence. There are a number of things. I'll give you 3 more examples. Let's see. Suppose I stabbed someone. Let's say that person was lightly stabbed and he was bleeding. Ambulance came, picked him up, and was taking that person to the hospital. While going to the hospital, that ambulance fell into a pit. वो गड्ढे में गिर गई, वो खाई में गिर गई, and everybody who was there in the ambulance died. Now the question is whether I have caused the death of that person. Whether I have caused the death of that person, the answer is no. Because his death is not the direct result of my stabbing, but rather it is the direct result of ambulance falling in the pit. The accident of the ambulance is the direct cause of that person's death. Now you can argue कि सर अगर आप चाकू न मारते तो एम्बुलेंस में न होता, तो वो एम्बुलेंस खाई में न गिरती, तो नहीं मरते. These are all things are correct. So my actions are a remote cause of that person's death, not the direct cause. Direct cause is खाई में गिरना, क्योंकि natural consequence नहीं है. See, you are only liable for the natural consequences of your action, not actually what happened. What actually naturally happens, like I'll give you an example. There is a Revaram Moti Singh case, sir. I stabbed someone and that person started bleeding, and because of excessive bleeding, that person developed a disease called hyperparaxia, which happens when because of the blood loss, the body cannot maintain the temperature, and that person died. Now the question is whether I have caused the death of the person. Answer is yes. Why? आप किसी को चाकू मारेंगे तो ब्लड निकलेगा, नेचुरल कॉन्सिक्वेंस. ब्लड निकल जाएगा. इफ द पर्सन लूजेस अ लॉट ऑफ ब्लड, the body automatically will fail to maintain the body temperature, because the blood actually helps us maintain the body temperature, and then the person might die by shock. In that case, the answer is yes, I have killed that person, because everything is a natural consequence of other. चाकू मारेंगे तो ब्लड निकलेगा ही निकलेगा. ब्लड निकलेगा तो बॉडी टेम्परेचर मेंटेन नहीं कर पाएगी, और वो मेंटेन नहीं कर पाएगी तो डेथ होगी. Everything is the natural consequence of another. But let's say there is an intervening factor, something which is not there. ब्लड निकला, थोड़ा सा ब्लड क्लॉट हो गया, उसके बाद उस व्यक्ति ने क्या किया, इंजेक्शन जो है, जब वो गए कि भाई मुझको टिटनेस का इंजेक्शन, वो जो है एंटीसेप्टिक इंजेक्शन लगा दो, इन्फेक्टेड सिरिंज से इंजेक्शन लगा दिया, उस व्यक्ति को एड्स हो गया, एड्स से मर गया. वो क्वेश्चन है कि मेरी गलती है. मैं कहूँगा भाई मेरी गलती नहीं है, बिकॉज आई हैव नॉट कॉज दैट पर्सन्स डेथ. सो माई स्टैबिंग इज अ रिमोट फैक्टर, है ना. बिकॉज आई स्टैब दैट पर्सन और आई इंजर्ड दैट पर्सन हैड टू टेक tetvac injection, and because of tetvac injection, that person that syringe was infected, so that person actually suffered from disease because of that, and AIDS ho gaya, and that person died. No, because the natural consequence is not there. Every time a person is stabbed, the other person does not contract AIDS. So in that case, the chain of causation is broken. The chain of causation should not be broken. नेचुरल कॉन्सिक्वेंसेस पे ध्यान दीजिए कि ए के होने का नेचुरल कॉन्सिक्वेंस बी है क्या, बी के होने का नेचुरल कॉन्सिक्वेंस सी है क्या. अगर वो चेन ऑफ कॉजेशन पक्की है, फिर तो लाइबिलिटी बनती है क्रिमिनल लॉ में। अगर वो चेन ऑफ कॉजेशन टूट गई तो लाइबिलिटी नहीं बनती है। जैसे कि सपोज आप लोगों ने हिंदी फिल्में तो बहुत देखी होंगी, इफ यू हैव वॉच्ड एनी मूवी, नॉट ओनली हिंदी, इफ यू हैव वॉच्ड एनी मूवी, what happens generally? There is a very important person who is supposed to be a witness or a link between the police and the main villain, and the police is chasing that villain, chasing that villain, chasing that villain, and that person uh, runs into a busy street or a car usko hit kar jati है and that person dies. How many times you have seen that? N number of times that has happened. कि भाई जो व्यक्ति होता है, he falls off a roof, he hit by a car or whatever the case may be. So suppose I'm chasing a person and that person is hit by a car. Question is that I have killed that person. Whether I have caused the death? Answer is no. No, I have not caused the death. Why? Because the generally the act of chasing will not directly result in the person being hit by a car. No, that is not the case. Suppose I was chasing a person and the other person, in order to save himself, jumped into a well and drowned. The answer is that I have killed that person. Answer is no. Because there is no consequence, there is no cause and effect relationship between those two things. If I am chasing someone, why will that person jump into the well? What kind of idiot jumps into the well in order to save himself? If that person was such an idiot, he died because of drowning. I didn't actually force him to jump in the well. So if he jumped on his own, that person is liable on that person is the primary culprit of his own death. I will not be held liable for that person's death. So it is only the direct results of your act that you are liable. If your action is one of the remote consequences or remote causes of that thing. Suppose मैंने किसी को धक्का दे दिया, ठीक है, और मैंने किसी को कहा कि जाओ ये काम करके आओ, है ना, that person was going and he is hit by a lightning. Now the question is whether I have caused the death. Answer is no. How come my acts का direct result है उसकी death? नहीं. So that cause and effect relationship must be there. Between what? Between the wrongful act and the forbidden consequence. Whatever you have done and whatever consequence has happened, both must have a cause and effect relationship. If there is no direct cause and effect relationship, the liability will not be there. And last but not the least, there is some injury or possibility of injury is must. If what I have done is inherently incapable of causing any harm. जैसे मैंने क्या किया, भगवान से प्रार्थना कर दी कि इस व्यक्ति को कुछ हो जाए, ब्लैक मैजिक कर दिया, तो obviously my act, whatever evil intention I might have, my actions are inherently innocent. Innocent in the sense not capable of causing any criminal consequence. Suppose I prayed, मैंने बिल्कुल, है ना, मैंने खूब पूजा पाठ कर ली, मैंने खूब दुआ नमाज कर ली in order to harm someone. I prayed so that other person might fall sick and person might die, and the person suppose actually fell sick and died. Now the question is whether you will be held liable. How many times I must, there is a highly likely that you must have heard it from your grandparents or even your parents that somebody is affected by najar, है ना, उसको नजर लग गई है, and that evil eye, है ना, has caused this particular problem, this particular trauma. अरे मार्क्स अच्छे नहीं आ रहे, नजर लग गई, ऐसा हो गया, नजर लग गई. So suppose somebody has faced a particular difficulty and they want to sue or file an FIR against the person who he thinks has caused this najar. The answer is that there is no liability, obviously, because there is no injury or there was never a possibility of injury. If there was a possibility of injury, the person can still be punished for attempt. If I suppose fired a gun and the person somehow was not harmed because the person moved at the last moment, there is a possibility of injury. But if I shoot a gun which has a range of 200 meters and I try to kill a person who is 5 kilometers away, there is no possibility of injury at all. So my actions will not be considered wrongful. In order to be wrongful act, there must be some kind of injury, harm, or there must be some possibility of injury. If there is no possibility of injury, absolutely no way that could have resulted in actual harm, the liability is not there. Then we have the idea of mens rea. Mens rea is what we call intent. Till now, we were discussing about whether the act is wrongful or not. What constitutes a wrongful act? Now we have something that we call mental element. Now till now we were talking about what you are doing, and now we are talking about what you are thinking. Mens rea is very important. You will have to prove that what the person did, whatever he did was wrongful, but what he did was also intentional. Some evil mind, it was not accidental or not unintentional, but rather intentional. He knew what he was doing. He wanted to achieve that thing. There is a famous MacLeod's case. Now, MacLeod's case is very, very interesting. In which what happened? It's a British case in which there was a husband who was cleaning his gun. And while cleaning his gun, there was a bullet in the chamber of the gun he was unaware of, and it was suddenly fired. And the bullet unfortunately hit his wife, and the wife died. That person was taken to the court. The prosecutor, the government advocate, they said, sir, it is very clear, it is open and shut. This person had the gun. The bullet was fired from that gun. The wife was dead because of that bullet. Now, obviously, it is, ये केस बिल्कुल आईने और शीशे की तरह साफ है मिलॉर्ड, है ना? The prosecutor said. The court said, no, you will have to prove that he actually wanted to kill his wife. It is true that that actus reus requirement is satisfied, that his act actually resulted in the wrongful consequence. But you will have to also prove that he intended the consequence that happened. It was not an accidental act like he was pleading कि सर गन साफ कर रहे थे और गोली चल गई. That's something that you'll have to negate. You'll have to give positive evidence to prove that he wanted to kill his wife. Now, that is difficult to prove, but that can be proved by surrounding circumstances, by motive and everything. But let's talk about various shades of mens rea. Shades of mens rea meaning thereby that these are the terms used in different provisions of the Bharatiya Nyaya Samhita. There are other terms as well, but these are the major terms that are used in Bharatiya Nyaya Samhita, and they all reflect a different degree of intent. First is knowledge. Knowledge is simply awareness about the consequence of your act. If you are aware that what is going to be the consequence of my action, then it will be considered that you have knowledge. If you are aware, ऐसा करेंगे तो ऐसा हो जाएगा. In that case, it will be considered knowledge. If you had no knowledge, like you are in a jungle and you see that the leaves and somebody is behind those bushes, you think it's a wild animal, you fire a gun, and there was someone who was a human, and Shravan Kumar Dashrath type situation happens. In that case, you can say, sir, I didn't know that what is going to be the consequence of my action. No? So knowledge is something when you are aware of the consequences. I know what is going to happen. Then there is something what we call intention. Intention is bada bhai of the knowledge. See, if you have knowledge that my act has this consequence, it does not mean that you always have intent, because intention is equal to knowledge plus desire to achieve those consequences. It must have knowledge plus desire to achieve those consequences. यानी कि जो हम आपको पता है कि ये मेरे ये करने से ये होगा और मैं चाहता हूं कि वैसा हो, I want that to happen, then it will be considered that the act was intentional. Only then it will be considered that you have a guilty intention. That is something very important. If you have knowledge and then you also desire those consequences to happen, in that it will be considered that you have intention. Now I'll give you examples that differentiates between these two situations. Sometimes having knowledge is different than having intent. Like I'll give you an example, very simple example. Suppose you are a loco pilot of a train. You are in the driver's seat of a train. The train is moving at, let's say, 100 speed, and you see that there is a person on the track. What you will do? Generally, you will do nothing because you can't do anything. Even if you press emergency brake, the train will again stop after 1 kilometer or so. There is no absolute emergency brakes in train. Suppose that there was such a system that the train can stop immediately, still you will not pull it because every person who is there in the train will derail. Every person who is there, inertia hits very in a very dangerous way. Everybody will face a lot of injuries. So you know what is going to happen if you continue, but you know, but you don't want that person to be dead. You know what is the consequence of your action, but you do not desire those consequences. The person will be run over. You will simply inform the headquarters that there was someone on the track hit by the train, died. But there is absolutely nothing that you can do. Doctors, when they are doing surgery, they know that the surgery is very risky. When they're doing some experimental surgeries as a last resort, they know that the person may die. They know that this particular action has a very serious risk of death is there. But whether they want that patient dead, answer is no. They're trying to save the life of that person while taking that risk. He has knowledge that my actions might cause the death of that person. But still, they have knowledge but not the intention. They are aware, but they do not want that person to be dead. That is the difference between knowledge and intention. Intention is something that you know the consequences and you desire those consequences as well. You want that to happen. You know कि आपके ऐसा करने से ऐसा हो जाएगा और आप चाहते हैं कि ऐसा हो जाए. That is called intent. Okay. Now let's talk about next two things. Again, these are two things are related. Recklessness means rash, reckless act. Reckless act very simply means that you are unmindful of the consequence. You are indifferent. You are not bothered about the consequences of your act. बिल्कुल आपने बिल्कुल आंखें बंद कर ली. Generally, reckless acts, आप सबसे prime example है reckless driving. When you are driving at a unusually high speed and you are unmindful or indifferent towards the consequence, whatever happens, what I do have to care. You are unmindful of the consequence, and I'll see what happens. Those cases are considered to be reckless. You are not aware of the risk. You are simply choosing to ignore whatever the risk that might be associated with your actions. See, every action have consequences. And if you are unmindful of the consequences, you choose to ignore whatever the consequences are, in that case, it will be considered as reckless act. Okay? Then we have negligent act. Negligent is something that you are aware that you had a duty to take care. You are aware of the risk and there was a duty to take care, a duty to prevent a harm from happening, and you failed to do that. That is called negligent. Like suppose I was supposed to have my car serviced after a period of time, and I don't do that, and my brake fails. In that case, I'll be held liable, I'll be negligent because it was my duty, because every machine requires some kind of servicing or some kind of maintenance. I failed to maintain my car, brake stopped working, I hit someone, I'll be held liable for negligence. Suppose I have wiring in my place and I fail to make sure that it is safe. There is a very unfortunate incident that happened sometimes back in Upkar cinema. There is a famous Upkar cinema fire case. There is a very interesting web series also on that, Trial by Fire. If you find time, you must watch it. It's brilliant. It's very good. It's Trial by Fire is about that particular incident in Upkar cinema where because of the faulty wiring, the whole cinema hall, it caught fire. Again, that was way back. Recently, I think in this monsoon, when I'm just recording this in 2024 at Jane of 2024, in this monsoon only, there was a huge negligence on the part of certain coaching institutes in Mukherjee Nagar, Delhi, where the classes was running on in basement, and the students were trapped and they drowned in the basement because of negligence. They had a duty to take care that you should not use basement for lectures and all. There was no way to escape. The channel gates were closed and the electricity, there is a huge problem associated with that particular. It was highly risky. And if it was risky, you were supposed to take protection. If you didn't, you will have to face the consequence. So negligence is also a prohibited mental state. Last is motive. Motive is something that is not required to be proved necessarily in a criminal trial. It is not an essential. It is not needed. Your motive is irrelevant for your criminal liability. Obviously, it can act as an evidence of guilt, but it will not affect your liability. Whether you will be guilty or not, it does not depend on the motive. If your motive was very good, but you did a crime, you will be held liable. If your motive is a very bad, but your action is not criminal, you will not be held liable. So motive is not very important. Sometimes there can be no motive, like a serial killer. Why he kills someone? Just for the sake of it, for the fun of it, the thrill that they get. There is no particular motive. They kill strangers. In that case, it will be considered that without motives, but liability is still there. Motive is something that creates intention. And now, what you are doing is intention. That I want to kill that person is intention. But why you want to do that is motive. Now, why you want to do that is very different. Sometimes motive can be as you must be a vigilante. like जैसे गब्बर is back. अभी वो movie आई थी वो उसमें अक्षय कुमार there are a number of movies which are revolve around vigilante justice. You might be someone who wants to make the right wrong by your own hands. That is also motive might be noble, but what you are doing is wrong. है ना? When the Bollywood tries to whitewash certain dreaded criminals, Once Upon a Time in Mumbai and a number of movies that Raif, a number of movies that the villain worshipping, sometimes in order to set a political narrative, they try to whitewash the criminals by putting up a simple smoke screen of good motive कि अरे नहीं नहीं वो क्रिमिनल रॉबिन हुड था वो डकैती करता था स्मगलिंग करता था लेकिन भाई गरीबों की मदद भी करता था नहीं दैट इज ऑल नॉनसेंस motive is not relevant for criminal law as the person will be held liable for what he has done and even that some person might say that I have a very good motive that is not important. So motive is something that is not very relevant for criminal law, but motive is something that leads to forming of the intention. Somebody has wronged me, somebody threatened my family, so I want to kill that person. So the intent is killing of that person. Why I have this intention is called motive. So that why is not required to be proved in the court of law. But if it is proved, it acts as a evidence against that person. If there is a question whether A killed B and A had motive to kill B is a relevant evidence against A. But proving that alone he had motive will not be considered essential for that particular trial. Or if it is proved that motive is there, it is not sufficient to actually implicate someone, punish someone, and not proving it will also not make it impossible to convict that person. That person can be convicted even if the court can, if it is the motive is unclear. Okay. Now, yes. Now, mental element as applicable in Bharat. Now, in our country, general rule is that yes, mental element is required. Some kind of intent is required. Almost all of the offences, the mental element is required to be proved. But see, mental element is obviously within your mind. So it is very difficult to prove. It is sometimes very difficult to prove. So in some offences, which are very serious offences, or which are offenses against the society at large. In those cases, the government actually changes the burden of proof. Burden of proof in the sense that uh, if you are found with cocaine, na, if in your bag, cocaine, police finds cocaine. Now, the police will not have to prove that you intentionally had cocaine in your bag, because the law says that we will presume you to be guilty. The mental element will be presumed by the court. When it is presumed by the court, yani if you have cocaine, it will be presumed that you knew it to be cocaine and you kept it with an intent to possess, distribute, or consume, whatever the case may be. Mental element is not required to be proved by the prosecution, by the state, by the government. And those offenses are called strict liability offenses. In those cases in which the mental element is written in the definition of the crime, like in murder, it is written, whosoever with the knowledge, whosoever causes death with an intention of causing death, or with such knowledge, with such intention. It is written that no intention and knowledge is a part of the offense. Where it is a part of the offense, the police will have to prove both the intent, yani mens rea, and also actus reus. But there are certain offenses in Bharat in which it is not required to be proved by the prosecution that you had guilty intention. The burden of proof, burden means who will have to prove. Generally in India, the burden of proof lies on the prosecution. Necessarily, burden of proof of proving all the elements of the crime is on the prosecution. Prosecution मतलब सरकारी वकील. सरकार आकर के साबित करेगी सर इस व्यक्ति ने ये क्राइम किया इस इंटेंशन से किया. They will argue, not the person who is the victim. Victim will not have to prove anything. It is the state who will bring a case against you. And it is considered a general rule that the prosecution has to establish both actus reus and mens rea. But strict liability offences are those offences in which the prosecution will only has to establish actus reus. Actus reus means they will have to establish that he had cocaine with him. They will not have to prove that he knew that this was cocaine. See, if the person who is accused, if he wants to prove कि सर हमको लगा था कि ये नमक है, ये बाद में पता चल रहा है कोकीन है, तो सर मेरी लाइबिलिटी नहीं होनी चाहिए. In that case, the court will say कि नहीं, आप साबित करो. So if you bring positive evidence to actually say that you had no knowledge that particular substance that you had was narcotics, in that case you will not be held liable if you can actually prove that. So strict liability offences are those offences in criminal law, and there are many offences in BNS as well as in other legislations like Essential Commodities Act. There is NDPS is there, and number of criminal legislations are there in which the police or the prosecution will not have to prove mental element. They'll just have to prove that this sir इसने ये किया. Ab, if you think that what you did was innocent, then you will have to prove in the court. इसमें एक बड़ा अच्छा एग्जांपल है डाउरी डेथ. डाउरी डेथ का एग्जांपल ऐसा है that डाउरी डेथ का offense says in BNS that if a married woman dies in 7 years of her marriage and she dies in suspicious circumstances, reason of her death is not very clear, and it is proved that she was asked dowry before her death, in that case we will presume that those who asked her dowry have killed her. It is unclear how she died, what circumstances she died. It is simply say if you prove 3 things. Number 1, she died within 7 years. Number 2, she died in suspicious circumstances. And number 3, she was asked dowry. We'll presume that those in-laws who asked her dowry have killed her. But if the in-laws will want to prove that nahi sir, we have not killed her, she actually died in an accident, she died because of an injury that we have not, she died by suicide, whatever they want to prove, they will have to give positive evidence for that. they will have to prove that in the court कि sir हमारी गलती नहीं थी, she died because of this. They will have to prove the circumstances of her death and that they have not killed her. Law will presume yes, yes, मान के चल रहे हैं हम लोग कि आपने ऐसा किया. These offenses are sometimes required क्योंकि मतलब डाउरी डेथ के केसेस बढ़ रहे थे, and even before anything could happen, फटाफट you kill the daughter-in-law and you cremate her and everything. But so that there will be no proof that how she died. So that is why this particular offense is included in IPC. That okay, you kill, if she died and her reason of her death is not clear, we'll presume that you killed her. Now nobody will try to hide the facts because they know if they try to hide the facts, liability will be there. Okay. Then we have vicarious liability in criminal law. What is vicarious liability? Vicarious liability actually means that crime committed by someone else and the other person is held liable. That also happens in criminal law. एक व्यक्ति का गिल्टी इंटेंशन दूसरे व्यक्ति को ट्रांसफर हो जाए. मैंने सपोज सुपारी किलिंग के लिए दिए, तो एक्ट मैंने नहीं किया, मैंने दूसरे से सुपारी किलिंग कराई, तो whether my liability is there is not, yes, my liability will be there because I helped that person committing the crime. I asked that person to commit that crime. Suppose there is a person who is committing a crime, I supplied him weapon, I supplied him vital information. All those person will be held vicariously liable. तो crime किसी और ने किया, liability किसी और की. वो कब होता है? जब आप साथ में कर रहे हो crime, या you are helping that person to commit the crime, or it is you who provoked that person to commit the crime. In all those cases, we will discuss that in detail when we will discussing abatement. But vicarious liability is also there. Sometimes it is not required that the person who is punished for the crime must have done that act by his own hands. He can use other humans as tools as well. Sometimes you don't commit a crime. हाफिज सईद ने आकर के यहाँ पे गोला नहीं चलाई, उसने अजमल कसाब को ब्रेन वॉश किया और यूज किया. बट हाफिज सईद इज मोर गिल्टी देन अजमल कसाब because he is the mastermind of that particular thing. So that is called vicarious liability. And obviously we have discussed principle of concurrence. The wrongful act and the guilty intent must coincide. इसमें बच्चों में आपको लास्ट में there is a very famous case Palani Goundan, Shorty and other cases are there in which the Palani Goundan case what happened? There is a husband he was beating his wife and he inflicted severe injuries on his wife, and the wife fell and the husband thought that she has died. उसको लगा कि इसका देहांत हो गया. अब what husband did, he took what he thought to be a corpse of his wife and hanged her, so that he can tell others that she has committed suicide by hanging herself. Now when he hanged her, everybody came and her body was taken into post-mortem. And it was stated that she actually died when she was hanged. Meaning thereby, she was not dead when he thought her to be dead. Husband जो था, जब उसको लगा कि इसकी डेथ हो गई है, तब उसकी उनकी डेथ हुई नहीं थी. लेकिन जब उनकी एक्चुअली डेथ हुई, उस समय से लगा नहीं था कि when she actually died, when the wife actually died, he had no intent of killing her because he thought that she's already dead. He was trying to cover his crime. So, as far as murder is considered, he was not held liable for murder. Why so? क्योंकि जब उसने मारा with an intent to kill, she didn't die. And when she actually died, this accused has no intent of killing her because he thought her to be dead. अगर सपोज मैंने किसी के सर पर 2-3 डंडे मारे और वो गिर गया नीचे, मुझे लगा मर गया, और मैं उसकी लाश को उठाकर ट्रैक पे डाल के आता हूँ ट्रेन की, कि भाई लोगों को लगा कि ये पटरी से कट के मर गया, और एक्चुअली ट्रेन जाती है, पोस्टमार्टम होता है, तो कोरोनर जो होता है, जो पोस्टमार्टम करने डॉक्टर साहब होते हैं, ही सेज दिस पर्सन एक्चुअली डाइड by the track, on the track, यानी कि he was actually killed by the train. He was not dead when the person who killed, who is the accused, thought him to be dead. तो यहाँ पे बच्चों को पता चलता है कि भाई जब जब उसका मर्डर करने का इंटेंशन था तब वो मरा नहीं, और जब वो मरा तब उसको मर्डर करने का इंटेंट नहीं था, क्योंकि इसको लगा था कि ऑलरेडी डेड है। तो यहाँ पे कंकरेंस नहीं हुआ, तो ऑब्वियसली लाइबिलिटी इज देयर फॉर अटेम्प्ट और ग्रीवियस हर्ट, बट एक्चुअल मर्डर की लाइबिलिटी नहीं बनी, क्योंकि एक्टस रियस एंड मेंस रिया शुड कोइंसाइड, दे शुड बी साइमल्टेनियस. At the same time, when you have caused the death, at the same time you must have the intent of causing death as well. So that is called concurrence. है ना, इसके बारे में आप लोग और डिटेल पढ़ सकते हैं, लेकिन this much, if you have understood this much, it is sufficient. If you want to learn, you can read the case of Palani Gaundan versus King Emperor. King Emperor versus Palani Gaundan. Palani Gaundan, you will search, you will get. You read that case, it's a very interesting case. You will learn about principle of concurrence. Okay, so this we have discussed elements of crime, and thank you so much for being patient listeners. If you have any specific queries, please, my email ID is on your slides. Please reach me at an image@mpnino.ac.in. In the next lecture, we'll learn stages of crime, and I thank you so much for being patient listeners. And I encourage you all to reach me if you have any doubts, any queries, and I'll be happy to be of any assistance, any help. Obviously, we are discussing principles and the things. Will take on a more practical or approach when we'll move ahead. We'll practice certain questions and answers, and we'll take comprehensions and everything. But let's clear our concept first. Okay. So if you have any difficulty, please let me know. And if I receive sufficient numbers of queries, if there are many queries, I will have a lecture on those queries as well. Okay. So thank you so much for being patient listeners. I'll see you in the next class. Okay.